Herkese merhaba. 10. haftadayız. Bu hafta iki konuğumuz var ve her iki konuda rekabet hukukunun amacıyla ilgili bir takım tartışmaları sizlere aslında sizlerin dikkatine sunacak. İki konuğumuz da yurt dışından olduğu için bu hafta böyle bir online bir şey yapıyoruz. Gelecek hafta her zaman olduğu gibi 11. haftadan itibaren zaten geri 3 hafta kalıyor. Kampüste olacağız. Okay. Let's now switch to English. Hi there, Sandra. Thank you for being with us today. It's a pleasure to host you. I wish you were in Istanbul and we host this seminar at the campus, but that's okay as well. Um, um, this is our 10th week at the seminars, and a little bit unusual for us to hold the seminars totally online, but it's sort of a break for us as well. It was a very busy schedule. We had like 9 weeks before with 18 topics, and today we gave a little bit break, and so everybody is like now watching this and listening us in front of their computers at home or elsewhere. All right. So we're going to discuss today two topics, and both are related to the purpose of competition law. And we will discuss especially non-economic goals of competition law. It's a little bit unusual, but for the past couple of years, this topic has been quite important. It started with the US, and now we are discussing within the EU law as well. And first, we will start with Professor Sandra Marco Colino'nun. Let me present her to you first. She is an associate professor at the Chinese University of Hong Kong. So she's now in Hong Kong, very far away from us. She specializes in competition law, especially. She joined the current university that she's working in 2010. She is now the Deputy Program Director of the Master of Laws in International Economic Law. She also serves as NGA to the International Competition Network and sits on the academic board of the law firm, Dictum. And she previously directed the Center for Financial Regulation and Economic Development and the summer schools in the EU competition law at the College of Europe. She holds a PhD from European University Institute in Florence and LLM from University of Carlos in Madrid, Spain. She's also a lawyer and a member of a Madrid bar. She has been working, as I said, in competition law. She has various research and publications in antitrust law, in competition law, in peer-reviewed journals and U.S. law reviews. She's the author of various books, including textbook on competition law of the EU and UK from Oxford University Press. Now it's in 8th edition, which is great. And she has a monograph. She's an author of a monograph called Vertical Agreements and Competition Law, and this is from Hart Publishing. And I think, well, the list goes on, but for our purposes, I think this is sufficient. Again, I'd like to thank you for joining us here tonight. And you have 40 minutes. After presenting your topic in 40 minutes, we will have a short, like 10, 15 minutes of Q&A, I hope. And the floor is yours. Thank you again.
All right. Thank you so much for your kind invitation. It's really a pleasure. And it's my loss not to be there with you. I was very, very keen on going, and I'm sorry that family issues got in the way. And actually this week we've been very, very sick. So I don't think I could have traveled anyway. Let me share my slides before we continue. Right. So today the topic that I chose to discuss is sustainability, inequality, and competition law. And these seem to be like just random words put together. So let me tell you where the link is and why I have actually written a paper on this, a very long paper actually on this. So the point of departure of my interest, of course, is as you've just explained, is the perennial debate about the goals of competition law. And that's, of course, also what Professor Brooke is going to be talking to you about. And this is something that she explores wonderfully in her book, and she explores the practical implications. I look a little bit more at the theory, and in particular at how recent trends are affecting the discussion and whether we can come to a kind of coherent policy following these recent discussions. So what we are seeing, it all comes down to antitrust is quite messy, let's say. It's political in nature. Its origins are linked to democracy, and yet we need to ensure legal certainty. We need to make sure that it can be applied in a way that it doesn't give the enforcers excessive discretion. So all of this leads to attempts, let's say, to limit antitrust, and tries to establish objective parameters within which it can be enforced, and of course setting objectives which are restricted, that can be measured with in economic terms, etc., etc. And that's where the discussion. So it's a little bit what Ole Sandriachuk summarized, saying that it's a tension between workability and predictability. We want to make it more predictable, but sometimes that means it's not workable, because sometimes by trying to limit the scope of antitrust, it doesn't do what we need it to do. So this is why, very well-intentioned people end up having these very heated arguments about what they want antitrust to do. Now, what we are seeing now is that what I realized in my recent readings is that there are two trends that come up in the literature that somehow have different consequences on the shape of antitrust. So one thing we read, the first of these trends, let's say, and this is not, the first one is not very new, is that if by enforcing antitrust laws, it's possible to narrow the wealth gap. And there's, of course, extensive literature on this, and even Nobel laureates have discussed this link. So this would mean, and as we will see in just a moment, that more antitrust enforcement could perhaps help combat wealth inequality. And a more recent trend is to discuss sustainability concerns in antitrust. And the idea that often comes up in the literature is we need less enforcement to enable sustainable cooperation between companies, and to make sure they can cooperate and engage in green initiatives, and antitrust will not stand in the way. So anyway, it seems that these non-competition goals, as we can call them, have the potential to affect antitrust in opposite directions. And this is effectively what I discuss in my one of my most recent articles, which is called Antitrust Social Ripple Effect, and is forthcoming in the Berkeley Journal of International Law. And if you want to read it now, you can click on the SSRN link on the slides. I hope that the slides will be shared with all of you. And otherwise, you can just find me, just do a search online, and you'll find my name on SSRN, and you can download it from an SSRN page. So just to dwell on that distinction of the more antitrust, less antitrust distinction. So the origin is in the idea that with regard to the wealth inequality, well, antitrust fights market power. And market power is often has a negative impact on wealth equality. So what tends to happen is that powerful players end up benefiting only themselves, and if they can behave in an anti-competitive way, they're going to do so, and therefore this would end up having a negative impact on wealth equality. And then from the perspective of sustainability, the idea is, well, sometimes when companies cooperate, so imagine a situation where companies are deciding an industry-wide agreement to engage to try to produce a more environmental product. What happens sometimes is that this has a cost, and that might be transferred to the consumer, so that will lead to higher prices. And sometimes the companies will also decide, well, we take the more polluting products out of the market, and that would reduce consumer choice. So is that actually okay, or could that be considered to be collusive by a competition authority? So that's where the tension comes from. Now, I just want to point out at this stage that this is an inaccurate perception. First of all, the literature is more expansive. So whereas we see, as I say, these are narratives that are very visible and that keep repeating themselves, and we see them very often, of course. But if you actually dig into the literature, a lot of the authors, a lot of the scholars that are looking at these issues are not actually saying that, especially when it comes to sustainability and antitrust issues. They're not saying necessarily that we need less antitrust. They're explaining a wide range of palettes, and in some cases, maybe more antitrust will encourage greener options. So let me just give you two examples of how this is not always the case. So it might be, if we think that, if we agree, and this is of course not everybody would agree with this, but if we agree that antitrust can promote innovation directly or indirectly, sometimes we see that innovation could be automation. So have more automated jobs. And this could mean, for instance, that the lower paid jobs are replaced with machines, and this could potentially have a negative impact on wealth equality. And from the perspective of sustainability, well, we've seen recently in 2021, some car makers that were fined for colluding to prevent innovation in diesel emission standards from vehicles. So they were just complying with the law, and although they had the technology to go further, they colluded not to do that. So the car makers were fined for engaging in collusion, in antitrust, but this also clearly had harmful consequences on the environment. So let's now, this is effectively the issue that I'm looking at and the impact that it's having on antitrust. So the first thing that I explore in the paper is there room in current antitrust policy for these non-economic aims? Should there be room for these aims? So, of course, we understand that consumer welfare in most jurisdictions is the main goal of antitrust. Now, if we dig a little bit deeper, we see that there's no consensus as to what consumer welfare really means. And there's no consensus even as to the aims of competition law. In different jurisdictions have sometimes different aims. But what the prevailing view is that consumer welfare equates efficient markets, that is high output, low prices. And this is effectively Robert Bork's view of consumer welfare, as in his very famous work, the Antitrust Paradox. Now, this is not really the same understanding of consumer welfare that we normally have in economics. This would be more like total welfare. But it's what stuck, and it's what has prevailed, at least mainly in the US, but also to a certain extent in other jurisdictions. So in Europe, the consumer welfare standard became more prominent when we began talking about the more economic approach. Back in the late 1990s, you probably remember the white paper on vertical restraints and all that came after that. There was a real attempt to limit the scope of what the European Commission was doing and try to set some boundaries. And one way of doing that was to kind of embraced the consumer welfare standard, but that has never been fully accepted. And we are still seeing now, I would say now we are seeing a kind of backlash to a certain extent, although the consumer welfare standard still is recognized as as the main goal of competition policy. We are seeing that, of course, that other aims are present. And what we are seeing also, of course, Europe has this market integration aim, which it never gave up on because the competition law rules are in a treaty, that the main goal is, of course, creating the single market. What we find at the moment is that we sometimes find decisions and judgments where the priority is consumer welfare. Other times we see the competitive process or the openness of the markets as being priorities. And overall, what we see in the black letter law is that more producer welfare does not always justify consumer harm, and also that benefits to consumers do not justify a complete absence of competition. That's how I would sum up a little bit the European approach. And as you know, there's been constant developments in this field, so there's a lot to unpack here. So can we take other goals into account? At this point, I will say, by the way, that the paper is comparative in nature. My article looks at the EU and the US. I'm focusing in today's presentation mainly on Europe. I have included a slide at the end. If I have time, I will sum up a little bit the situation in the US. But I thought that would be interesting because like you've just explained, the debate of the goals perhaps comes from the US, but perhaps the sustainability issues is something that emerged mainly in the European context, the discussion, and now it's also going back to the US. So it's kind of these are systems that clearly mutually influence each other, and the discussions, of course, are crossing the Atlantic quite easily. So what we are seeing is that in the US, there is an ongoing discussion to replace considering the possibility of replacing consumer welfare with another standard that would allow more intervention. And we've seen things like the competitive process, which I just mentioned, quality of life, well-being. And this is at the core of the new Brandeis School, which you will know has become extremely popular, with now Lina Khan being the chair of the Federal Trade Commission. And she is, as you know, the author of the Amazon Antitrust Paradox, which is probably the best known article of last decade. One article that has been not only just extremely well cited, but that led her, before she finished law school, she already became a very popular in antitrust circles. So there is a feeling that in the US, the discussion is perhaps trying to break with the system, whereas in Europe, any changes have been taking place mainly within the boundaries of this more economic approach, even though, as I say, we've seen a policy that is in constant evolution. So EU competition law has always been infused by the goals of the general treaty goals, even though, of course, as I said, we still recognize consumer welfare as the main goal of competition policy. Even in the most recent policy briefs of the European Commission, this is a present idea. So can we take other goals into account, and should we take other goals into account? Well, we have some problems that we need to bear in mind. The first is that the alternatives that we have been discussing with regard to other goals have not been fully convincing. So I remember a lot of professors who are not entirely happy with this standard, but they're saying, well, we can't really find a better one. So that's one of the problems that we are facing. Another problem is that competition law is helpful, but it is not maybe the perfect way to pursue some of the goals that we are discussing here. And the tools that competition law provides are limited, and we need to acknowledge those limitations. And the third problem is that by perhaps setting ourselves a very complicated task, we are also putting in the hands of the enforcers huge discretion. And of course, having said that, in the EU, we have significant legal guarantees. We have the possibility of appealing the decisions of the Commission and the administrative bodies enforcing the law. So there is a system in place, and perhaps these problems are not as conspicuous as they would be in other jurisdictions. But these are certainly things that require, that at least call for some caution. So let's now explore what I want in the attempt to provide some consistency. I would like to explore these two options of less antitrust and more antitrust, that these two goals would perhaps suggest that might be possibilities. So the first thing I wanted to say about the less antitrust option is that what we see, if we really look closely at what is being said, is that we are not talking about saying, well, suddenly sustainability should be a goal of competition law. What is being said is perhaps sometimes sustainability matters more than good markets, than markets that work well. So perhaps sometimes we need to set aside the application of competition law for something that we are valuing more. And I have some examples here, and this is expanding a bit on what I said earlier, right? The need for when we have, when we want to introduce environmental standards and we want to introduce a new environmentally friendly product, there may be costs involved. So the idea is if a company does it on its own, it might suffer from what we call first mover disadvantage, meaning that its products will become more expensive and suddenly it will lose out. If we are thinking consumers might still prefer the cheaper alternatives. And of course, we are becoming more and more aware of the need to purchase environmentally friendly products, but not everybody is aware, number one. And the second thing, not everybody can afford the more expensive products. Some people, some of us are still need to think of the budget and think to go for the more affordable option. So to avoid this first mover disadvantage, what businesses tell us is we need to move as an industry and we need to adopt industry-wide standards. And this means that we are effectively coming together to discuss prices, or we are coming together to, or our conduct is going to have an impact on price. And as I said earlier, if we take out the less sustainable products out of the market, then we are reducing consumer choice. How is this compatible? Are you going to punish us for doing this? So clearly, this is the issue that is at stake. Now, there is significant doctrinal support in what has been labeled the green antitrust movement. And I would say perhaps wrongly labeled green antitrust movement, or at least it's a label that has been very limited, because if you look at the authors talking about green antitrust, they are referring exclusively to those calling for less antitrust. And that is a little bit unfair because, as I said earlier, many authors are looking at this topic and exploring a wide range of options. So I think that, and this is a second paper that I've actually written that is also on my SSRM page, called Antitrust Environmental Footprint. And what I say is, well, actually, perhaps we need to reconsider this term, and we need to consider the green antitrust movement also, including those that are calling for more enforcement and to use antitrust to actually target conduct that is also harmful to the environment. So anyway, if we are deciding, if we think that the right thing to do is to make exceptions to antitrust, how can we do this? Well, the first and most obvious option would be to use Article 101.3 of the TFEU, which means that if the 4 conditions are met and there are effectively countervailing efficiencies, then the agreement can be exempted from the prohibition of Article 101.1. And this has happened in practice. So we have seen an agreement between manufacturers of washing machines to produce washing machines that were more energy efficient. Pardon me, and where the consumers actually also saved a lot of money on energy bills was exempted. And the reason why it was exempted was effectively because there was a calculation of the savings, and they would compensate the extra cost of these more expensive washing machines. But there was also mention of the potential social benefits. But we also have unsuccessful examples of the application of Article 101.3. And the most glaring example is the very famous Chicken of Tomorrow case, where the Dutch Competition Authority felt that it could not exempt an agreement where the producers of chicken meat had come together with local supermarkets, and what they were going to do is they were going to produce chicken meat with higher animal welfare standards, higher environmental standards, and that was going to raise the cost of the chicken meat, and they would take the cheaper meat out of the market. It would not be sold in the supermarkets. And what the authority found, it was that effectively consumers were not willing to pay for the very significant increase. And it was a very significant increase. And they did gather expert reports that said that the impact on animal welfare would really, really be minimal of the measures. So they would have a bit more living space, a little bit more daylight, and these things would not really have a huge impact on the welfare, the well-being of the animals, and yet they had a huge increase of the cost. So anyway, and by the way, we should also mention, while talking about Article 101.3, that there has been, and there was an instance, the consumer detergents case, where the company started cooperating and to produce a more environmentally friendly detergent. And in the context of that, the discussions to implement that lawful agreement that was exempted under Article 101.3, they effectively ended up colluding, and one of them applied for leniency. So this also needs to be taken into account, that sometimes even well-intentioned environmental cooperations can end up leading to collusion. So anyway, some of the issues that have come up is that it's very difficult to demonstrate when consumers are getting a fair share of the benefits. This is one of the 4 requirements for the application of Article 101.3. And the new horizontal cooperation guidelines actually give some light in this. And they say 2 things. First of all, they give some guidance as to when sustainability standardization agreements might be exempted under certain circumstances, when the market share of the parties is below 20% and they meet certain requirements. And then there are different ways of demonstrating that consumers get a fair share of the benefits. So normally the traditional view is the consumers that pay for the increase in cost, they should also be the ones benefiting. And the Commission has tried to be a little bit more flexible here. So there are 3 groups of potential consumers that can benefit, that can be 3 kinds of benefits that can be taken into account. First would be the typical benefits, where the individual use value benefits, so when the ones paying are the ones benefiting. But there is also another possibility of individual non-use value benefits. So if we are not the ones benefiting, but we see the value, we actually appreciate environmental initiatives, we are environmentally minded, and therefore I don't mind paying more. And if that group of consumers is willing to pay, then we can accept that even if they don't benefit, they're willing to pay perfect, so that we can count that requirement of Article 1013 would be met. And then there is also the possible consideration of collective benefits, but collective benefits can only be taken into account if, so this means this would be a situation where the individuals don't want to pay, they're not willing to pay for the environmental benefits, but actually ultimately their group benefits from the consequences of that price increase. So in that case, it's possible to take into account collective benefits, but you can see it's a very, very kind of a very small window that the European Commission has opened. The second option for exempting or for not applying Article 101 would be the Wouters route, and this is something developed in the case law. And the idea would be, well, some agreements are not caught by Article 101 because there is a legitimate interest, and provided that they meet certain requirements, then they will, subject to the proportionality test, then they will not be caught by Article 101. Now, the legal profession has sometimes benefited from such exemption, and also the sports. And you probably are aware that late last year, we had a very nice trilogy, very comprehensive trilogy of cases, including the very famous case of the European Super League and the International Skating Union and Royal Antwerp, where the European Commission, where the Court of Justice tried to explain how special is sports activity and how sports governing bodies can set rules without falling foul of competition rules. Now, what we found out that affects us is that actually this route is only applicable if the restrictions are not restrictions of competition by object. So here it would be a little bit challenging for the kind of industry-wide agreements that have an impact on price and that could reduce consumer choice. It might be a little bit challenging to see this route applied. Now, I would say, well, it's true that it's difficult and it's not something that the European Commission nor the courts seem to favor, but it might not be a bad thing because, as I said earlier, environmental aims have been in the past misused to implement a cartel. Sometimes it's not necessarily that less antitrust is going to really have a very significant impact on environmental benefits, and yet there is a lot at stake because diluting antitrust also prevents us from reaping very important goals for society. So anyway, this is something that I thought that I consider in the paper. And also I mentioned, by the way, that it's a little bit, one of the unfortunate consequences of this idea of collective benefits, that they can only be measured, they can only be taken into account if they benefit the consumers that are paying for the goods. It kind of rules out what happens very often, that we have very big firms that have the factories in very, very far away lands, and the consumers paying for these goods are actually in the countries where these big companies are. And then it would not, since they would not be benefiting from this cleaner air, would make it very difficult to consider these collective benefits to exempt these agreements. So we certainly don't have a perfect system, but this is the way that the European Commission has tried to preserve the robustness of antitrust. So what about the more antitrust option? And this can be, of course, an option both for sustainability and for wealth equality. So the logic of more antitrust stems from the criticisms to the Chicago School, this consumer welfare standard, perhaps the overly lenient approach. And what I'm saying, I know it's very controversial. Not everybody would agree that the approach of the Chicago School is excessively lenient. But this is perhaps something that we are seeing now in the literature. And the idea is that if we fight market power a little bit more strongly, that could lead to greater equality. So we hear all the time, well, it's not about the problem that we see in antitrust is not about holding the market power. It's about misusing market power. But it is true that market power harbors many risks. So can we perhaps change this perspective and decide that we need to do something about the mere existence of market power, for instance? This would be one of the perspectives. But anyway, what would be the benefits of antitrust enforcement for equality? This was actually recently highlighted by Professor Ariel Ezraki from Oxford University in a paper. And he focuses not so much on having wealth equality as a goal of competition policy, but the external effects, perhaps the unwilling effects of antitrust enforcement on equality. And what he and his co-authors have found is that, well, if we enforce antitrust and we get better prices and more choice, this would increase the wealth of consumers. And as I say here, well, if markets work well, this can improve living standards, or at least slow the decline of those living standards, improve opportunities for those at the lower end of the salary scale, promote social mobility, etc., etc. So those would be all ways to enhance equality. So what would be required? Well, perhaps a change of aims of competition policy. This is a complex issue. But we could simply stretch the boundaries of current policy, right? So for example, take a tougher stance on dominance, on mergers, perhaps focus on specific sectors that have a greater impact on wealth equality. And I talk about the possibility of focusing on the indirect effect of EU competition law. Just focusing on the possibility of the benefits, the social benefits that may be derived, and not just for wealth equality, but also for sustainability of the application of competition law. Another thing that could be done to enhance enforcement would be to rethink the burden of proof imposed on competition enforcers to prove the existence of a breach. So sometimes, as you know, it's very difficult to prove that a breach exists. The European Commission has lost some fundamental cases because the court found it had not quite proven to the requisite legal standard that case. And one wonders, when we see especially litigation ongoing for decades, whether the burden may be just a little bit too high. And again, it's very difficult to reconsider this because, of course, we have to defend the rule of law. But there have been proposals as to perhaps when there is conduct that looks very blatantly anti-competitive, maybe to require the Commission simply to very quickly to show this and then to reverse the burden of proof, to make the company show that actually they had some objective justification, or that the conduct was somehow explained by some means that is not anti-competitive. So if you want, later in the question time, I can look at the US, but in the US, what we are seeing is that the debate regarding sustainability and antitrust is very, very young, but we are seeing it has been a little bit politicized, and some of the investigations that have been triggered there are actually rather questionable from an antitrust perspective. And this has led a lot of authors to say, well, look, here we see clear examples of antitrust trying to, or possibly stepping in the way of very laudable green initiatives. But actually, these initiatives then were not crushed by the investigations that were launched. And actually, the investigations have been questioned, they are actually now also being looked at to see whether they may have been wrongly brought by for reasons that were not really justified. So anyway, it's a much more complex picture and very different from the picture in Europe. Now, some ideas that I put forward in the paper is that the first would be that, you know, antitrust is not really perhaps the best tool to pursue these social goals, but it can certainly support these. And as we will see later in Professor Brooks' presentation, and as she proves in her book, it's clear that enforcers often have to balance these goals, and they do take these into consideration in practice. In Europe, we are seeing this very clearly. The second thing that we need to bear in mind is that, of course, the business community plays a very important role in defending sustainability, equality, etc. But at the end of the day, there should be other policies that are more important, because ultimately businesses are profit-driven. And sure, they may very well have very laudable concerns, and they may be acting, you know, in some cases altruistically, but more often than not, understandably so, they have a responsibility with their shareholders, and therefore they need to be making profits, and they need to increase their profits. And that means that sometimes they would put profit over these goals. So while we can let them be innovative and we can give them some leeway to work towards these goals, we also need to be aware that the rules must be applied. And most of the time, what they are going to do is not going to be caught by antitrust. They can do so many green initiatives and so many things that can boost these goals that would not fall foul of antitrust rules. So anyway, what I say here is that perhaps the best route would be to boost enforcement, and this would need, of course, clear parameters and principles. And that seems like the better option rather than weakening antitrust enforcement. So just some conclusions, and with this, I would love if we open the floor for discussion. There are, of course, various goals valued by society, which interact with competition policy objectives as we understand them today. And we need to take this into account, of course, and taking them into account cannot always be done in the same way. So of course, ideally, I would favor a case-by-case approach, but we need some bright lines. This is clear. I find, and I think I show in my research, that the idea that antitrust hampers sustainability is somewhat exaggerated. We don't really see this really sustained by the facts. It's very rare. Although theoretically this is a possibility, it's not something that we see a lot in practice. And what we see is that what we probably see if we look at the evidence is that agencies would need discretion to assess these factors. Guidance from these authorities is useful, and that is what is happening. We are seeing a raft of guidelines coming from the European Commission, the different national competition authorities. But we need to adopt probably a holistic approach to competition law, acknowledging that balancing of goals actually takes place, and looking at treaty objectives. And even though this is somewhat complicated, it is perhaps something that it is a necessary evil, something that we cannot avoid, and that actually in practice, probably as we are going to see with Professor Brooks' presentation, is something that is taking place. And with this, I end. Thank you very much, and I look forward to the discussion. Thanks.
Thank you very much, Sandra. And you're right on time. We started around 7:55, and it's 7:45 now. And now I turn to our viewers and listeners. And if someone has a question, please, you can raise your hand and I see Armanç and Altekin as they have raised their hands. I'll start with Armanç. Armanç, please.
Well, thank you very much for the presentation. It was really engaging, and it's good to be able to discuss these issues both with you as your background, with your background, and with the audience. So I would, like to kick the can down the road and ask some questions so that we can both maybe discuss these issues. And I have two questions. The first one is, when we're talking about the goal of antitrust, at the heart of it, we have consumer welfare, which is undeniable. But we also have this total welfare approach, which I think maybe better encapsulates the benefits of innovation. And innovation, in the long run, is the key factor to make markets better, services better, or to give us things that we do not imagine to have right now. So there is that approach as well that should be recognized. And sometimes the consumer welfare in the short run and total welfare approach with innovation in the long run can become mutually exclusive, and they cannot always work together, at least in the short run. When we are in that position, which one would you think to prioritize? Consumer welfare approach or total welfare approach?
Yeah, it's a very good point. And that's, that's one of the key questions. So what I actually do, so let me just be very clear. I actually, my aim is, it's not so much I analyze. There is a part of the paper where I analyze all this background and the total welfare and the consumer welfare, and the fact that when we actually say consumer welfare, we often mean total welfare when we're talking about the perspective of Borg. What I try to do, and I think this is relatively feasible in the EU, is to say, let's take what we have, right? Rather than continuing this goal discussion, right? Let's assume that the goals are the goals that we have accepted since, in the last 20 years. And of course, there's already some discussion there. So what can we do to ensure that we have an antitrust policy that is robust and that at the same time, it doesn't turn its back on other developments, on other very important goals? Now, my main concern here, and this is so I leave the door about whether we should opt for consumer welfare or total welfare a little bit open. Because it's a perennial discussion. I'm not going to settle it, but I think that we need solutions, right? So I think that what concerned me and what kind of led me to write this paper is the fear that there is a risk that we are forgetting, and some of these papers are so well intentioned, we are forgetting the value of proper functioning markets and the importance of the goals of competition law and the role that competition law serves for something equally important or as important. But sometimes that we are talking about a conflict that isn't really there. And I think in Europe, the literature in Europe has picked up on this in a much more thorough way, I would say, than the literature in the US. Perhaps because the US situation has been so politicized that, as I say, we had the Trump administration intervening to declare illegal or declare against competition law an agreement that was reached between car makers and the state of California to reduce emissions below the limits that the Trump administration has set. And this agreement was not anti-competitive, and it would have been very, very hard to say that this was contrary to Section 1 of the Sherman Act. Very difficult. But it made headlines. Look at this. Look, antitrust is preventing car makers from doing something that is actually beneficial and green. And of course, it's understandable that people would worry about this, but actually that's not really the problem. And people like experts like Professor Hovenkamp were saying, well, it's not, even if we try to apply the law, look, these are the requirements that would need to be met. The government is going to really struggle to prove that all of these requirements are met. So it's not really a case. So it seems that we are getting scared or running away from something that is not really a real fear. And that's why I also wanted to publish this article in a US journal to hopefully reflect that and to hopefully insist on the importance. And actually, Lina Khan also writing in the Wall Street Journal mentioned also about how now it's very fashionable to say the mergers, sustainability issues in merger control, how important they are. And she was saying, well, I can only assess the impact of the merger in the markets. I can't look at another unrelated market and seeing whether or not this is going to have another benefit. Of course, we have to limit ourselves to this. We have to limit the analysis. So that's more what I'm looking at than basically choosing the final goal of competition law.
Well, thank you for that. And if we have time, I can squeeze in one more question. Which is, all of our discussions point out to the fact that competition law is a dynamic field, and the goal of it, to the extent we dare to define, has to be dynamic as well, because the subject where it regulates is dynamic. The markets are changing, innovation, technology, and whatnot. So there's no doubt about that, that we need dynamic enforcement. But what's not dynamic, and maybe even static, is the procedural rules. And sometimes, especially when not we, of course, but when in countries like Turkey, especially when competition authorities or enforcers try to use competition law to react to popular issues, maybe inflation sometimes, or loss of buying power might be related to something going on in the market, maybe not. But when we use these existing mechanisms, maybe a little out of their goals, original goals, to react to certain topical issues, we see that the procedural rules are static, not dynamic. So the goal, on one hand, has to become dynamic and be able to flexible, while the set of tools and procedures we have are not. So what do you think on that? How should we maybe work around that, or should we work around that at all? Is this something you consider?
Yeah, what I said is, of course, the problem that we have is that we need the procedural guarantees. That's clear, and we need this is why the procedural rules are so important. I would agree with you that this is one of the problems that we are facing. The solutions, we can talk about very general solutions, but actually executing those has proven to be very, very challenging. So this is what I have, what I find in the paper, that I do think that something could be done, but how to exactly work around that without leading to arbitrariness in procedure, etc., is complicated. Yes.
Yeah, it's a fine line. Oh, thank you for that.
Thank you.
Thank you very much, and thank you, Sandra, for the answers. I'll take it. You have raised your hand. Do you still? Okay. You wanna pose your question?
Thank you, Professor, for the insightful presentation. I have yet to read your paper, but I have a general question regarding broadening the goals of competition law. We all know that throughout the history, many different political ideas have affected competition law. And we know that the objectives of competition law are constantly changing by the use of different institutional and political ideas. That's the reality. And also in the current state, with the use of price-centering tools, apart from digital markets, we can measure economic efficiencies easily, right? More or less with the data available. But in terms of green antitrust objective, what would be the benchmarks applied to most cases? What I'm trying to ask is, it seems that these standards are also subject to change often in the wake of an environmental crisis. Is it feasible to include these benchmarks to the analysis of competition law? Thank you.
Yeah, so I mean, of course, the main discussion, I mean, this is clear, of the environmental standards is outside competition law. This is clear. So the idea is the only, I mean, the way that it affects our field is or why this is, you know, being discussed in a particular way is, well, what can how can we, or this is how I would see it anyway, you know, how can we ensure that, yes, competition law doesn't stand in the way of potentially beneficial cooperations? And as I say, we don't have a lot of evidence that it actually does, despite all this talk. But of course, I mean, we have this Chicken of Tomorrow case and others that we do have some environmental initiatives that in the end were not upheld. And by the way, we also have a follow-up investigation conducted by the Dutch Competition Authority that suggested that the goals of the agreement had been met by the companies acting independently. So that's also something worth considering. Now, the way that I think it's a mistake. Of course, it would be a mistake to think or to say, you know, to declare, right, that competition policies should in a way expressly pursue sustainability. But it's not impossible. I mean, I look at certain cases, recent cases of the Commission, apart from the case relating to what I just mentioned, the diesel standards of the car makers. You probably are aware of these very big fines imposed on the trucks manufacturers for in 2016, 2017, these record-breaking fines for cartel conduct. And there was also an environmental angle to the conduct of these trucks manufacturers. We are seeing now also the Commission often pick cases in areas relating to waste, in areas that would have an environmental impact. Now, that's not to say that, oh, this means that the European Commission is clearly thinking of sustainability when it's enforcing the law. No, but the Commission has to make some enforcement decisions. I don't know if you remember recently, I saw a post on LinkedIn talking about the Director General for Competition having said recently, well, we tend to pick the cases that we have more chances of winning, which is kind of the lowest hanging fruit. So there has to be a case selection. Well, it's no bad thing to select cases that might, by enforcing competition law, there may also be a beneficial impact on the environment, as in these very recent cases that we have seen. And this is about, you know, the sectors, the kind of violation involved. So that is, I think, the way perhaps to address this, perhaps by setting priorities, by prioritizing cases that also have an environmental angle, as well as perhaps some others that may be of particular importance also to the European Commission and this would be also, you have to think it would be in line with other treaty articles, because Article 11 of the treaty says we need to interpret all of the European policies in a way that protects the environment, or that with a view to sustainable development, sustainability. So, of course, there is a justification. There is a clear reason for doing this, a clear mandate, you could say, right? So that is basically my point.
Thank you very much.
So much.
Thank you very much for the question and answer. Is there any other question? Kadir, do you have a question or?
Yes, I have a question. You can hear me, right?
Yeah.
Yes.
Okay. Firstly, thank you very much for presentation. It is really very controversial topic. We said that, you know, environmental considerations are not actually a part of competition law, at least not one of the goal of competition law. My first question is whether we can consider these considerations as a quality of the product, because under Article 101.3, the first condition is it must create efficiencies. and there are qualitative efficiencies as well. So, for example, two companies establish a joint venture to produce a new car. This car may not be cheaper, but it may be more environmental friendly. This would be considered, I think, as a efficiency, and this may be a result of this may result in giving an exemption to the agreement. But I think the problem arises where this could lead increase in prices. I mean, for example, in my example, if two companies, two competitors come together to produce a new car, not cheap, but environmental friendly, if this will not avoid them producing the other cars cheaper, but not environmental friendly, this would be okay, I think. And but the problem here, as you give example of chicken, and it create a new product maybe, but it would deprive consumers of the cheaper products. So the question is here whether the qualitative efficiencies would outweigh price increases. I think the competition authorities, commission or other authorities, I think their duty to balance them. But I think the problem here, do you think that this environmental based, friendly based efficiencies could outweigh increases in price?
So that is what thank you. So this is what the new horizontal guidelines, the horizontal cooperation guidelines try to address, because there's been so much talk about this. So actually there's also a draft version of sustainability guidelines in the Netherlands, which were a little bit more open to assessing, like you're saying, these qualitative benefits. So the problem is with this second condition of Article 1013 that I said before. So the idea that consumers need to get a fair share of these returns. And we still are mainly doing basic calculations to see whether or not the economic gains, the economic costs are outweighed by some kind of economic gains. So what we saw, for example, just to give you an idea, even back in the 2000 case of the washing machines that I talked about earlier, which was an agreement that was exempted back when we needed to exempt these kinds of agreements. So this was a situation where the Commission measured both the benefits for the individuals paying for the washing machines, but also for society. And they said, well, it seemed that the advantages for society would be 7 times greater than the increased cost of these washing machines. But ultimately, even though this was considered and this was praised, the general idea that the societal benefits, in terms of cleaner air, effectively, the reason why it was exempted was because of the savings in energy bills to the individual consumers. So this is, at the moment, this is where we're at. And we have seen, even recently, the Dutch Competition Authority managed to exempt an agreement between two companies for the storage of CEO, effectively, and it found its conclusion was something like, well, the agreement, we can find that the benefits outweigh the costs. So there was the traditional view. But even if they didn't, we could also have considered it positively, effectively. So the Dutch Competition Authority has shown a willingness to maybe adopt a more qualitative approach. But ultimately, what we are seeing is the prevalence of the quantitative approach. And in fact, it's no bad thing, in the sense that, as I said earlier, we also need to protect. It's not a perfect situation, but we need to protect the competition law system itself. And I'm not sure that, as at least from the research that I conducted in my paper and what I show in my paper, that we can justify diluting the application of competition law rules for this quite a small risk that is posed by this very specific situation of these kinds of cooperation.
Thank you very much.
Thank you very much. Do we have any other question? Well, it seems that that's all from the audience, and it's already very late there. I know it's coming to 1 o'clock, and we just don't want to keep you more.
My pleasure.
I'd like to thank you again for your informative presentation, excellent presentation. It was very nice to have you here, and I hope to see you in Istanbul sometime in the future in person.
I too hope so. Thank you so much.
Thank you very much.
Thank you, Professor, for coming.